I call Jonathan Young.
Thank you, sir. I'm pleased to rise and stand. I would like to make some brief introductory comments on this bill that we're looking at the Committee of the Whole House. This is because I chaired the Transport and Industrial Relations Committee and I was away from Parliament at its second reading. I'm not going to make a second reading speech, sir, but I just wish to make some comments. The Transport and Industrial Relations Committee, by majority, recommended the bill not be passed. I understand the member, acknowledge him here today, has brought through some SOPs, and I do acknowledge the intent of the sponsor of the bill, Honourable David Parker, to protect some of the most vulnerable workers in our workforce, sir, who he believes are working in contracting arrangements but may be receiving less than the minimum wage. So many of those working in lower paid contracting industries are overrepresented in New Zealand's low income statistics. Those overrepresented include women, Maori, Pacific Island people and disabled people. And sir, I believe the reason why we as a committee cooperated with the member and gave him adequate time and officials to look at potential solutions to this problem is because I think, sir, we all agree that we don't want to see vulnerable people being exploited, and we are not for that by any means. Some submitters consider that contracting arrangements are becoming increasingly common, so businesses can reduce costs, avoid the duties and obligations that they attach to employers, such as holiday pay, sick pay, employer accident compensation and levies and the like, such as that. And sir, those are great concerns. We did hear anecdotal stories, so we are able to understand how some people feel, but we were unable to ascertain actually how big this problem was, which we made comment about that in the report. I think we acknowledge that there are some issues in the workplace for low-paid workers who are classified as contractors. But the issue, we believe, certainly this side of the House, is not adequately remedied by this bill. But ensuring a contractor's remuneration is no less than the minimum wage, which is what the intent of the bill is, does not, we believe, meet the bill's intended outcome. As noble as that outcome is, as contractors still have their ACC levies, their sick pay, their holiday pay deductions to be made, after which the balance a contractor may receive could still be less than the minimum wage. I think, sir, as we progress through consideration of these matters, we came to understand that there is quite a distinction between those who are self-employed or contractors and those who are employees, and there seems to be, sir, an opportunity for clarity to come and I'd say regulatory monitoring of the classifications that workers are under. And I think, sir, that it would be fair to say we believe that this is the nub of the issue that needs to be addressed. Instead of actually treating every contractor as an employee, i.e. making their remuneration to be a time-based payment as opposed to other forms of contract arrangement. Sir, so we oppose the bill, although we understand the intent and support the sentiment of that. We oppose the bill not for political reasons at all, but for practical reasons. And that we do not believe that they address the real issue. Sir, can I just highlight in my time that I have right now just to touch on some of the reasons why. We believe that there are existing provisions in the Employment Relations Act that address the problem that this bill seeks to remedy. The problem the bill seeks to remedy is workers placed in employee-like situations, but as contractors, without the benefit of employee protections, such as minimum wage, entitlements, etc., as I have mentioned. The remedy proposed in the bill is to require principals engaging contractors and those providing Schedule 2 services to record the time a contractor takes to undertake the work and the remuneration paid. Then to maintain those records for not less than 6 years as evidence that they have paid the minimum wage or above. So I understand that some of the thinking behind this bill come from, and Sir, happy...
Jonathan Young.
Thank you, sir. Just happy to reference this point, the International Labour Organisation's recommendations on the Employment Relations 2006, the recommendations number 198, Articles 4A, 4B, which state this: national policy should at least include measures to provide guidance for the parties concerned, in particular employers and workers, on effectively establishing the existence of an employment relationship, on the distinction between employed and self-employed workers. All right, now we understand Labor government in 2006 endorsed these, and rightfully so. And that also national policy should combat disguised employment relationships in the context of, for example, other relationships that may include the use of other forms of contractual arrangements that hide the true legal status, noting that a disguised employment relationship occurs when the employer treats an individual as an employee in a manner that hides his or true legal status as an employee, and that situations can arise where contractual arrangements have the effect of depriving workers of the protection they are due. So, sir, we understand those measures in that recommendation that was endorsed by the then Labor government. But, sir, Article 8 says this, and this, I think, sir, is perhaps the point of difference, or the point that we feel should not be contravened. It says national policy for protection of workers in an employment relationship should not interfere with true civil and commercial relationships, while at the same time ensuring that individuals in an employment relationship have the protection they are due. So essentially what we're doing, in order to fulfil Articles 4A and 4B, we're putting in a process where contractual obligations and commitments are being narrowed down to be based and measured on an employment basis, which is an hourly rate. And that, sir, I see as an interference of true civil and commercial relationships. And I think that the objections that we are hearing from the commercial and contracting fraternity in our country is that though they agree with the intent that vulnerable people must not be exploited, they do not want to see the interference in civil and commercial relationships, but there has to be another way to address this problem. And that's what we believe. We believe, sir, that there are many other measures to do that, and no doubt, perhaps in time, I'll take another call, hopefully, and be able to address that. Thank you, sir.
I call Ms. Galloway.